Lucky for me, since we're a little time crunched, the next two speakers really do not require an introduction. We have Mark Richter, I will be very brief, and Steve Rice. They're probably known to many of you in the room. They are true experts in the field. I'm sure they will provide some interesting conversation, a little bit of healthy debate back and forth. They have both chaired the lead conference in the past, and I will let you listen to what they have to say. Thank you, Mark and Steve.
Okay. All right, good morning. It's still morning. It's been a long morning. Wow. Let me begin by just saying, thank you, Brian, and thank you, Patricia, for putting this event together. I know it takes a lot of work. It's hard, and I'm sure everyone here appreciates it. I also want to thank Roy. Roy, your city. I love it. Thank you for welcoming us to your city. I enjoyed it last night. I'm not going to say that is going to affect my ability to present today, but it might. Well, good one. Good one. Okay, well, when Patricia asked me to speak at this year's conference, I was a little reluctant. Having spoken at the last two conferences, I thought it would be time to take it a little easy down here in the Big Easy. She sensed my reluctance, and so she provided me with a deal I could not refuse. First, she said, Mark, you can speak on the first day, the first morning, when people are, still either sleeping or focused on lunch, and so that was good. I appreciated that. And the second thing was she offered me a topic that did not require a lot of heavy lifting. What I'm discussing today is pre-suit settlements. It's not a very controversial topic, like that low-level exposure issue. This is a pretty easy one. I do not anticipate Steve Rice hurting me too much when he gets up here, but who knows? And that leads me to the third incentive that she gave to me. That was my co-panelist is Stephen Rice. And after she said that, I said, sign me up. Yeah, no, it's true. It is, it's true. Boy, my voice, I think I did lose my voice last night. Okay, and this is being recorded. Don't send this to my wife. Okay. Now, there are some downsides. Oh, thank you for putting that up. There are some downsides about speaking what I'm talking about here today. Tom Cullen, he left, didn't he? Yeah, he did. He snuck out, didn't he? Oh, and I caught him on that. That's funny. Tom Cullen talked about, a little bit about, the secret trade, secret informations, but it's pretty much all out there anyway. I mean, we know what we're doing. Most lawyers in here have tried one or two lead poisoning cases, so there's really no secret here. It's pretty much all open for everybody to know about. So I'm not worried about that downside. I'm a little bit more concerned about the second downside, and what I'm talking about is pre-suit settlements. Pre-suit settlements. Half of you, at least, I think, are defense lawyers. So if I'm settling these cases pre-suit, your bread's not being buttered. So I apologize to you for that, okay? But I know that a lot of the carriers do speak with their defense counsel when they're trying to negotiate these cases pre-suit. So anyway, before I move on, I will make one other point, and that is I'm from New York. So some of the cases that I talk about are from New York. I do think that they span jurisdictions. I think they're relevant whether you practice in Baltimore City or down here in New Orleans. So that's it. Let me see if I can figure this out. Okay, first question. Oh, by the way, do you like that? It's a New Orleans theme if you haven't picked up on that. I came up with the colors myself. So who do you represent? Potential plaintiffs. Well, gosh, I really wish Tom was in here. Tom, are you here? Tom? No? Who do you represent? The children. The lead-poisoned children. Those are potential plaintiffs. And if Tom was here, I was going to change that phrase for him. I was going to say something like, we represent the children who were allegedly exposed to lead from some undetermined source at some undetermined location, and most definitely not one of Tom's client's properties. But no, he's not here to enjoy that. So the children, that's certainly who you are going to consider representing. Now, we're finding more and more, we're getting some kids coming through the door who aren't kids anymore. I mean, they're like 20 in New York. You got a statute of limitations that's up at 21 years old. So, do you have enough time to take on their case? Well, obviously, you're going to need a couple, 3 months to do a thorough investigation. I mean, first of all, you have to figure out, was this kid ever lead poisoned or exposed to lead? So you're going to have to go get some public health nurse records. You're going to get the DOH records to see if there were hazards at any of the properties that they lived at or visited. And that takes some time. So you got to be mindful of that. Once that you get the Department of Health records, then you're going to know, what the child's blood levels were, where they lived, where they visited, and if there were hazards there, and so on and so forth. So if you're lucky enough to get those records and see that there was potential exposure, then you can go ahead and file suit, and then you have to go get all your other records, your school records, your medical records, maybe DSS records. Well, not maybe, yes, DSS records.
He's back.
Oh, Tom is back. Oh, Tom, you missed. I gave you at least 3 shout-outs in the last 5 minutes. You missed them all. 2 of them were funny. Okay. Now, so anyway, if you're right up against the statute of limitations and you don't know all the facts, should you sue it? Probably not. I mean, I think there's some ethics rules that say you can't bring frivolous suits and you have to have a legitimate basis to file a claim and things of that nature. So, if you're right up on the statute of limitations, kind of dangerous. Now, oh yes, this happens quite often. I'm not even looking at my PowerPoint, so I don't know if what I'm saying jibes with this at all. But, if you're coming up close to the statute of limitations and you know that there was potential exposure, you know that there were hazards, but you're not sure if there's insurance coverage, what do you do? Well, I think you got to file suit, and you have to have a conversation with the client that, hey, listen, adult plaintiff now, I'm giving you a retainer agreement which thoroughly states, it's a CYA thing, says, hey, listen, I haven't had enough time to do a full investigation. So if we should file suit and later find out that there's no insurance or we have a judgment-proof defendant, you're going to let me out, okay? I can withdraw. Put that in your retainer agreement. It's just a CYA. Now, what happens if the child comes in and he's too young? What do I mean by that? Well, obviously, if he comes in a stroller, okay, you're not going to be able to determine what is the nature and extent, if any, okay, for the defense people, of the child's injuries. We all know that before you can give a pretty accurate assessment of the damages or injuries that you're going to be claiming for your child, the child has to be old enough to submit to a neuropsychological exam. So really, you got to be grade school. Typically you're looking at 7, 8 years old before you can even think about filing suit. So what happens if that child comes in and you think, gosh, this could be a good case? You plaintiffs, lawyers out there, you know this. This is tough. Our clients change addresses more times in a year than most of us do in a lifetime. And you don't want to lose them. So what you do is you get the records, you preserve the records, you put the insurance company on notice, that whole late notice thing. But we're going to talk about insurance later. That's not my gig. Somebody else will talk about that. So you put the carrier on notice, and then you stay in contact with them because they are going to move. And that valuable case that was in your door, you're never going to find them again. So that's just a little tidbit for you. So, what am I doing here? What am I doing? Okay. Oh yes, who do you represent? Who else? Parents? No, thanks. We've had parents come in saying, but I've been hurt. I've had to pay for this. I've had to deal with my kids' problems for the last some 10, 15 years. I'm entitled to something. Well, a derivative claim is never, ever a good idea in a lead paint case. The focus has got to be on the child's injuries, not the fact that the mother is looking to try to get some money for herself. It's going to take the focus off the child. You don't want to do that. Also, and this is a problem, as we know, at least in New York, and I'm sure it's the same in a lot of different jurisdictions, once that you make that parent a party to the case, now they're a party to the case. She's not there in a representative capacity. It's her. She's putting her physical, mental, emotional condition into controversy, and now guess what? The defense actually may be right, and they may be able to get her records. I don't like that. Obviously, the parents may have some background information that's not beneficial to your case. Another good reason not to bring a derivative claim. Now, if that parent absolutely insists on being joined in the action, thankfully, her statute probably is blown. It's 3 years. Sorry, should have come to me 12 years ago. That's it. So, where am I? Okay, I think I said all that. Okay, multiple plaintiffs. Do you assert the claim separately or together? Well, that's a good question. What are the benefits of suing them together? Well, economies of scale. These lead cases can be very expensive to litigate. Depositions, record gathering, a lot of time, a lot of energy. So if you can do them both together, streamline it, great. You probably have some cost savings. Are there drawbacks to doing that? Well, I think so. I think if you have two kids in the same lawsuit, you could potentially water down the potential recovery of them. There's also a potential conflict. There are always potential conflicts. I mean, you're representing two kids. Let's say there's $300,000 of coverage. You get a kid with a 32 blah blah level. You have a kid who was chelated with a 54 blah blah level. It's worth more than 300, assuming there's liability. I got it, defense people. But it's worth more than the 300. And now you have to share. You have to whack up that 300 of insurance. There's a potential conflict there. You need to obviously talk to your clients about that. I know I'm going to go over. I really thought for sure. I know I have a lot more time, I hope. But I really thought for sure, I was going to need like 2 minutes. But so I apologize to you in advance. Feel free, though, Patricia.
I'll throw something at you.
Please, let me know. Okay, now, what is the other potential drawback of suing the cases together? Well, one of the plaintiffs might have a checkered past. I'm just saying, these lead cases, it's possible. There could be a kid that you represent that got in trouble with the law. Could miss some school. There could be some pins or other issues which a jury may not look favorably upon. I know in a lot of our cases, you'll have like an older child, a younger child, maybe there are several years separating them. The older the child gets, the more likely that child is going to be susceptible to some adverse conditions. Maybe some criminal conduct, as I said. So that could be a downside if you take the two cases together. Because, I know we've had cases before where, the kids come in, everything's looking pretty good, but these cases take a while. And you always say to the kids, I know I've done this several times, I sit them down and I say, stay out of trouble, get into trouble and this is going to really hurt your case. And lo and behold, 10 months later, they're in shackles. And there goes the value of your case. And that's not going to help the other plaintiff who actually has a clean background. And it's not just criminology or the propensities to commit crimes that's an issue. You could have one kid that maybe there were confounding factors during his or her birth. Maybe it's a crack baby, or maybe the failure to thrive. Who knows what? And a jury might have a hard time differentiating between your two plaintiffs, and it could affect the cleaner of the two cases. So, now, okay, pros and cons of suing separately. Yes. Well, a benefit is you get to depose that landlord twice, 2 bites of the apple. Conversely, the downside is the landlord is going to be able to depose, your guardian or your mom twice. So, it goes both ways. And obviously, there's some potential conflict issues. If you're suing them separately, it's going to take you more time. There's going to be more expense. But keeping out the negative background, that might be worth it to you to do that. Now, what are some of the other considerations in deciding whether or not to sue the cases together or separately? Again, statute of limitations. Do you have enough time to finish the older kid's case before you start the younger kid's case? If you don't, and then you end up having to sue the second case, there's going to be a motion to consolidate. That's just going to muck up the works. It's going to delay the case. So think about that. If you have to sue them together, you sue them together. Inconsistencies between the two cases. Oh, do I need to be on another slide? Let's see. Yeah, okay. Inconsistencies between the two cases. It happens. You have a child who has maybe 64 blood level, okay, and is doing okay in school. I'm not saying the kid's going to go to Harvard, but the kid is doing well. But yet you have the second kid who has a 21 blood level, repeated grades 3 times, okay, has been in special ed since, the very beginning. And it may be difficult for a jury to comprehend how how lead played any role in the ladders, the 21 level child, in that child's diminished performance when you have a kid with a 64 that, got a regular diploma. So that is also something that plays a role. I think this slide is going to say something about ethics. Yes, it does. Good. I was talking a little bit about the conflict issue. You're not going to get, it only took me 28 minutes to figure out there's a screen right here. I can actually see what's on the board. Nobody told me that. That's great. I feel like the president here. Well, ethics. You need to, if you're going to be representing multiple plaintiffs, whether it be the same family or not. I mean, because let's be honest, we have a lot of cases where there's a property and you could have 2, 3, or 4 different families who live there and are suing the same defendant at the same or at different times. So what you need to do in New York, and the rule is, and I'm just going to read this because I think it's hilarious. In New York, a lawyer shall not represent a client if a reasonable lawyer, how do you define that? I mean, I don't know. If a reasonable lawyer would conclude that the representation will involve the lawyer in representing differing interests. And notwithstanding the existence of a concurrent conflict of interest, a lawyer may still represent both clients if the lawyer reasonably believes that he or she would be able to provide competent and diligent representation to each affected client, and each affected client gives informed consent confirmed in writing. Okay. So what do? You talk to the clients, you tell them the potential ramifications of you representing both of them, and you get them to sign off on it. CYA, ethics. You just got 0.1 credit for ethics right now. Okay, so now what do? You've conducted your research, you completed your investigation, you've given disclosures, you've gotten written consent. Who do you sue? Landlords and their managing agents. That's a pretty easy one. Most cases that we bring these days are still against the landlords and their managing agents. And you know who they are because you go to the Department of Health records. You do title searches and you find out who was involved. You should immediately get letters out to the landlords and to their insurance companies to put them on notice, as I discussed. Another potential defendant are neighboring property owners. Believe it or not, we're seeing this from time to time where, our child lives at one property but spends a lot of time outdoors, and the property right next to theirs has an exterior that's full of conditions conducive to lead poisoning. I just wanted to say that. It's full of lead hazards, that are peeling off the side of the house, falling on the ground, and the children like to play with those lead chips because they're sweet. And so I'm told. Anyway, so can you sue that neighboring landowner? Yes, you can, because a neighboring property owner owes, even though your client's not a tenant of theirs, a landowner still has a duty to exercise reasonable care and skill in the maintenance of his or her property to prevent his property or a substance thereon from endangering the public. We had a case recently in upstate New York, Whitehead versus Wilson, in which the lower court held that the neighboring property owner, even though he wasn't the landlord, could be held liable. Now, contractor, this is an interesting one. Independent contractors, abatement contractors, can they be held in a case? They can. I just had a case a few months ago in Albany County Supreme Court where we sued the landowner, the landlord, and his painting contractor. And the painting contractor said, hey, wait, you can't sue me. There's no duty between me and this injured kid. And generally, that contractor would be right. The general rule is that an independent contractor will not be held liable for injuries sustained by non-contracting third parties, such as an innocent passerby. But there are 3 exceptions to that rule. One exception is if the plaintiff detrimentally relies on the continued performance of the contracting party's duties. Didn't apply in our case. Second, the contracting party has entirely displaced the other party's duty to maintain the premises safely. You're not writing already, are you? Oh my gosh, I can't believe it. That's basically if the independent contractor had exclusive control. Very rarely does that happen, so go on. The third factor, or exception, applies, and in our case it was when the contracting party, in failing to exercise reasonable care in the performance of his duties, negligently creates or exacerbates a dangerous condition so as to have launched a force or instrument of harm. And by doing the remediation work in such a way that it exacerbated the toxic condition, whether it be by way of lead-based paint chips that are now being dispersed throughout the apartment, or whether it be the dispersal of lead-contaminated dust, good enough. We survived summary judgment on that. My gosh, I have 3 minutes, less than 3 minutes. So here we go. Ready? Who else do you sue? Doctors, the lead med case. I think we are all familiar with that. I'm not going to go into the standard regarding what you have to prove, but generally, physicians are required, at least in New York, to perform lead poisoning risk assessments and provide lead poisoning anticipatory guidance. If they should fail to do so, they might be subjected to liability. So you want to make sure you get the pediatrician records. Paint manufacturers, I've never commenced a case against a paint manufacturer. I know these suits are very involved and have generally been unsuccessful, but that's always potential. Municipality, we used to sue them until the Court of Appeals said we can't. Unless the municipality owns the property. Okay, if multiple defendants, can you settle prior to suit? It depends. In New York, you have these 2 rules and laws that talk about if you settle with one defendant, what's the effect on non-settling tortfeasors? And of course, the non-settling tortfeasor is entitled to a set-off, whether that be in the amount that was paid in the settlement by the settling tortfeasor, or whether that be by the equitable share or relative culpability of the party that settled out with you. It depends on the facts. The interplay between these 2 statutes is very, very confusing, but it is very important, because if you're trying to figure out if I have to go to trial with this remaining defendant, how much exposure does this defendant have? You need to know how this works. And here it is for you. It's very confusing. Ready? Did you get it? There it was. What? No? You didn't read that? Oh, can I go back? Yeah. If I had like 20 more minutes, I'd read it to you. But you'd still not get it. It's like the rule against perpetuities. I'm still trying hard to figure it out. Okay, assessing a defendant's relative culpability. Kind of obvious stuff. Don't show me any more time. Going fast. Okay.
Relax.
All right. Obviously, defendant's knowledge or notice of hazards. Did one defendant know that lead was potentially hazardous to a child and the other defendant didn't? It's relevant to know that. It'd be even better if both defendants had prior lead hazards. You have the notice, right? In New York, notice is a requirement. Right? Get that out there. How did each defendant respond to the notice and demand letters? Was it timely? Was it proper? Did they botch it up? Was it delayed? All relevant considerations in trying to assess, can I settle with this defendant versus this defendant? How much time did your child spend at the property? Were they just visiting? Were they there just every other weekend? What were the BLA levels at each property? Were they going up? Were they going down? Some say the first cut is the deepest. That Rod Stewart song or whoever else sang it. But that's a consideration. Boom. How much do you demand? Well, I get flack for this all the time. Well, how much insurance do you have? Defense lawyers, they really don't like when I ask that question. But it's so relevant, because if you have, a $100,000 policy, chances are in most of these lead cases, the case is probably worth it. Just saying that, okay? But if there's $2 million of coverage, I can understand why it doesn't make sense to demand the $2 million. You lose credibility, you lose respect. You have to be reasonable. Anti-stacking non-accumulation clauses in some of the case law. Gosh, I wish I had more time. We are going to be, I think the next session deals with insurance, but there's been a lot going on in New York regarding these issues. I know some of the cases, this Geraldo case, Greenwich Green, so on and so forth, have generally held that, you get one policy and that's it. But those cases dealt with situations in which there was one child, one tenancy, one apartment, one set of hazards, okay? But most cases don't fit that mold. A lot of cases you have child 1 living in the property in 1992, child 2 moving in 3 years later in the second floor apartment with different set of hazards. How in the heck does the non-accumulation or anti-stacking clause apply to that? I don't know. Well, the lower court up in Monroe County recently was presented with this issue in the Nesmith case. And the court held that really you cannot conclude that there's just one policy under those facts. There should be full coverage to the tune of $500,000. That case is up on appeal. It's being argued on the 24th, so next week. So we'll see what the appellate division has to say about that. Okay, how much do you demand? Well, what have your other cases settled for? What have been the verdicts in your area? Jurisdiction often plays a role. There are some jurisdictions, we know where they are, that are not pro-plaintiff. There are others that are better. Be mindful of that. If you can sue in a jurisdiction that's pro-plaintiff, you're going to do that, even if it means you have to travel. Be able to compare and contrast, the good cases and the bad cases. How much do you demand? Don't demand the policy except in rare circumstances or when there's minimal coverage. Yeah, well, that, you just need you need to take a hard look when you get these cases in. You need to, early on, figure out, which facts hurt you, which facts help you. Don't be, looking to get, the $2 million if the case is not worth it. And the word that I used, and I'm going to use, and I'm going to get flack for it, is you got to be reasonable. I'm sorry. Anybody laughing, defense lawyers, snickering at me? Yes, Jim Tyree is. I think Rick Weber, shout out to you. I know that, right? Yeah. No, you got to be reasonable. And I'm not saying you should, sell your case short or undervalue it. Just take a hard look at it early on. I know in my law firm, we'll sit down around the table, we'll round table it, and we'll come up with a number early on. Like it's the drop dead. This is the bottom line, that we will recommend to the client to accept, and that we'd recommend. And if we don't get to that number, we move forward with the trial. Now, this is Tom. You're here now. I'm going to give you a little shout out again. Ready for this one? You were talking earlier about like sitcoms, like from the 70s and 80s. You were reading my mind. Here's one. Ready?
You're not going to sing it.
Oh, I'm singing it. You take the good, you take the bad, you take them both, and there you have, boom, that's life. I mean, you don't know it, do you? Oh my gosh, now we're seeing our generation thing going. You see, I think I'm in that Generation X, not the Generation, I don't know what they are. But all right. Hey, listen, the cases are what they are, Okay, how much do you demand? Know your carrier adjuster. Okay. Oh yeah, you got to know how they play the rules. I mean, every adjuster's different. Every lawyer's different. Are they going to do the back and forth game? You kind of need to know that because you don't want to give them your bottom line and then have them come back, 200 grand less. Oh yeah, I like that. I'm getting really good at this PowerPoint stuff. I created that. Yeah. So that means don't be pie in the sky. Be reasonable early on. Demand letter, settlement package. You got to say it's for settlement purposes only. You're going to be providing documents in your settlement package. Make sure you reserve your rights and privileges, and because there could be some confidential information in there. We always like to provide a very detailed outline of the case, even like a timeline. We'll show what our kids' blood levels were. We'll show all the properties where they were living. So it simplifies matters because these cases can get pretty overwhelming and complex. You also want to be able to discuss previous settlements and verdicts. Relevant legal precedents. This is a big one. Insurance companies, and I don't blame them, it's business, they like to point the finger at other places. I mean, obviously our kids haven't lived at the same property for 20 years. They're going to be living at other properties, they're going to be visiting other properties, they're going to be with their grandmother, they're going to be with a babysitter, they're going to be at daycare, and the insurance company is going to want to minimize their carrier's involvement. Is that a 0 or a 1?
That's a half.
That's a half. Okay. So discuss some legal precedents. I know in New York, one of the good ones is this indivisible injury rule. So you know what? My kid was poisoned at property 1. My kid was poisoned at property 2. No expert's going to be able to come in and say, these brain cells were killed at property 1, but these brain cells were killed at property 2. It's an indivisible injury, not subject to some sort of a practical division. As such, property 1 and property 2, both of you are on the hook for the whole injury. That's a good one. Also, the 1% rule. This is dealing with joint and several liability. Although you get that in New York, Article 16, where if you're under 50% liable, you can limit your ultimate liability with respect to pain and suffering. You can't do that with economics. So if the carrier says to you, yeah, but we're a minor player, yes, you're a minor player. I just need the 1%, and then I get all my economics from you. And that's a good argument, especially when you have the other defendant who's judgment-proof and so on and so forth. I know I'm out of time. Demand letter. And this I have to give a shout out to my colleague, Kelly Michaelis. Thank you very much for reminding me. You have to obviously know how much insurance is available. Recently, we've been hearing about insurance companies that have been making these side agreements with their insureds, saying, hey, listen, even though you've got 100 policy, we'll indemnify you regardless of what the verdict is, because the carrier feels that strongly about their position on that case. We're only going to offer 20 grand or whatever, take it to trial. We're entitled to know that. I mean, that's, the CPLR is clear on that. You want to set forth the terms of your settlement, payment terms. No, we don't agree to confidentiality. If you're going to do an annuity, a structure with annuity, we agree to do a co-broke. We'll satisfy the statutory liens. What documents do you provide? Just provide what you got. Don't hide it. The case is what it is. It's going to come out in the wash. Defense lawyers, adjusters, the companies, they know what they're doing now. Just give it to them. And if there are issues in your case, and chances are there are confoundings, get them out early, and then, distinguish them away. There was some alcohol, prenatal. There's cigarette use prenatal. But I got an APGAR at 1 minute of a 9 and a 9 at 5 minutes. There were no complications. The baby was healthy. Next. So don't fear the confoundings. Deal with them and get rid of them. I think my time has develop rapport with the adjuster. Obviously, this is common sense. Build credibility with the adjuster. Give them what you get, how you get it. Don't manipulate the documents. If there are any smoking gun documents, well, make another copy, and you can show them that. But definitely don't be manipulating with any of the documents. Make fair and reasonable demands. And good luck. Thank you. That's it.
Hi there. So there are two things that the purpose of this speech. One is to try to educate, at least to some extent, the people in the room. And the second is to make sure everybody gets to lunch on time, and I'm really not sure what the more important aspect of this is. So let's just get right to it. The purpose of this discussion is really to lay out what pre-suit steps can be taken to try to get a case resolved. And I'm defense counsel. I'm not an insurance adjuster or an insurance professional. But I've always believed that the money is the money, and if you can save money on the defense end, then the client should be happy. And if it's money that's paid for defense as opposed to money that's paid on the indemnity end, well, it's all the same money. And so the best thing that we can do in representing a client is to try to get to the shortest distance between 2 points, which is a straight line, and that is to try to settle the case as soon as you can for the best possible deal. So, this is a mature subject. Dave Governo reminded me, he chaired the first lead conference 20 years ago when I was there. I think Benji Hill was there. I'm not sure who else in the audience today was there. But the bottom line is that we all know a lot about this subject. And so if you're trying to put the case into a framework where you can try to settle the case early, then common sense needs to apply. So the first thing I wrote was, that's not it. There we go. Coverage affects everything. And obviously, if it's an uninsured defendant, that's a whole different issue, and I'm going to leave that out. But coverage affects everything, and so the first thing that needs to be done from the perspective of the insurance professional is to confirm coverage. And there are obviously different types of policies, so that plaintiff's lawyers or people representing the plaintiff need to be savvy to that too, because there are notice requirements that obviously might be written into some of these policies. standard form ISO policies are one thing, but there are policies with lead exclusions. There are policies that apply only to lead. There are policies that incept with 25 micrograms per deciliter. There are policies that incept at 15. There are also policies that require the initial diagnosis of the elevated lead level to be within the same policy period as the notice to the company. So it's in large measure, it's to the advantage of the plaintiff to get the insurance carrier on notice as quickly as possible, just in case one of these policies is written like that, and now you're at least within the coverage, whereas they might have had an excuse to disclaim at some point. So obviously then the next thing is that the insurance professional needs to confirm the coverage dates with the dates of the claim, and when in doubt, shout out to me and everybody else in the room who defends these cases, retain defense counsel, get yourself a coverage opinion, and so that you know what your rights are and what you can move against, et cetera, et cetera. But with the eye toward trying to get the case resolved pre-suit, that's the purpose of this discussion. So if there are defenses to the insurance policy, the insurer needs to get a reservation of rights letter out as quickly as possible. In most jurisdictions, usually within 30 days. And that letter must be sent to the insured. It must also be sent to the plaintiff's attorney, and any other entities that are interested. Reprise, coverage affects everything. Well, what does this mean? Well, the extent of the investigation that's going to be done and the entire tenor of the discussions that are going to follow are going to be dictated by how much coverage there is. So if it's a case with 7 figures of coverage, there's considerable more risk than if it's a low 5-figure or 6-figure policy limit, and the type of investigation is clearly affected by that. First notice to the insurer. Sometimes it's the commencement of the action, sometimes it's a letter from the plaintiff's lawyer, sometimes it's notice from the client or the broker. Notice requirements vary between states, and everyone needs to be aware of what the notice requirement is in the state that they practice in. So there's a query here. Does a violation in the building trigger the obligation of the insured or the insurance broker to notify the carrier? And does the failure to do that give the carrier a position to disclaim for late notice? That needs to be dealt with. It needs to be dealt with very early. I know I'm moving quickly, but I'm going to get you guys out of here by lunch. Once coverage is confirmed, okay, what are the next steps in terms of pre-suit? Investigation of the facts. And here comes the search for partners and the spreading of the risk. So investigation of the facts, certainly you got to start with the building that you're in, the maintenance history. Look, let's back up a second. It's also important to know who the adversary is on the other end. If it's Mark's firm, I think anybody that has dealt with Mark's firm knows that they do a very thorough investigation before you ever hear from them. So if there's another residence, for instance, and they haven't sued them, you could probably figure out there's a pretty good reason why they didn't sue them. Maybe they have no coverage, maybe the place was renovated, who knows, but there's probably a reason why that wasn't done. So if you're looking toward, getting to the shortest distance between 2 points, you might want to skip a few steps if you know the reputation of the plaintiff's firm and you can make certain assumptions. Partners. Well, who are the other potential sources that your client or your insurance company have for additional money that might be put towards a settlement of this case? So there are the coverages for the insureds. I mean, the bottom line on a lot of landlords is that they'll let their broker go out and search for the best and least expensive coverage each and every year or each and every time the policy is about to expire. So if the lead exposure is alleged over a long period of time, the chances are you've got more than one carrier involved. So the primary carrier needs to go out and find the others and bring them into a cost-sharing deal to save money, number one, on the defense end, and number two, to share in whatever the indemnity might be. Prior and subsequent owners of property that the plaintiff may have lived in. Other premises includes other residences of the family, the grandparents, the caregivers, the schools, and the daycare. And as Mark mentioned earlier, with respect to anticipatory guidance, you have the potential for healthcare providers and also contractors. Pre-suit teamwork is very necessary between the insurance professional and the defense counsel. I think that's pretty obvious. It's common sense. Only really the defense attorney is in the best position to evaluate the jurisdiction and the venue, to provide an analysis of what the local regulatory scheme is, to provide some insight into the reputation, the capacity, and the capability of the plaintiff's lawyers, and to provide an estimate of the settlement values. So best practices for trying to settle a case early. Communication between the parties. You know, we've litigated against each other, and I know when I start a trial, I need to remind my client that they're going to see me smiling and or talking nicely with my adversary, because this isn't the only case that I'm going to have that person on. So don't be surprised if you see each other and we look like we're friendly adversaries. So the point is, you know, get along with your adversary. You don't have to be burning bridges on every single case, because what goes around comes around. And this is a very small community. We all gather here once a year. We all know each other. And if I have you under my thumb on one case, guaranteed you're going to have me under your thumb on the next one. So develop a trust. And if you can develop a trust, you can share documents, you can talk honestly, maybe you get rid of the case. Pre-suit best practices. Teamwork between the defense counsel and the insured. I went backwards. That's good. There you go. Okay. Pretty clear that, you know, unless you're willing to take what's being told to you on blind faith, then you've got to go out and get the records. It's pretty obvious. Move on to the next one. Coordination and teamwork. Once again, I think I covered that. Initiative can come from the insurance company. It doesn't necessarily have to come from the plaintiff in order to settle. When I was preparing these slides, you know, I spoke to a bunch of insurance professionals that I deal with all the time, and a term that kept coming up pretty often is, are we willing to buy the risk? And you know, and it does benefit all of the parties if in fact the carrier can you know, get to a comfort level fairly early. Set the tone for the negotiation. Know the range and value. Justify the offer. And I've been told this too, avoid lowball numbers. I mean, lowball numbers don't get you anywhere in a negotiation. They're just like the same idiotic highball number, a lowball number cuts off the discussion and doesn't do any good. So find the number that makes the most sense in terms of keeping the discussions going if your intent is to try to settle. I got 2 more minutes. Red flags for the insurance claims people. Alternative causes for the claimed injuries, and evaluation of the parents, the confounding factors. There are many, many, many confounding factors that relate to what happened to little Johnny and what condition he might be in at that moment. Maintenance history of the subject premises. Is this place truly a source of lead, or is there some reason to suspect that the lead exposure took place elsewhere? Experience level of the plaintiff's attorney, and again, the jurisdiction of the venue, and I did it. Thank you.
There is one question for Steve that was passed up, and if there are, and it's in quotes, side agreements between 2 insurance carriers, are plaintiffs entitled to that information in writing in order to negotiate on an even playing field?
You know, I don't have any experience with side agreements. I don't even really know what Mark was talking about. Not to say that it can't occur, but I've never seen it. And to the extent that there's some kind of side agreement, I'm not certain that it would be discoverable. I'm not even sure what the effect would be. So I really can't answer the question. I don't have any experience with it. If anybody in the room does, feel free.
I think I would disagree with Steve there. If, at least in Maryland, we are entitled to know what the insurance limits are by way of asking interrogatory and getting a response. And if there's a side agreement between carriers that says we'll pay X and we'll pay Y, I think plaintiffs' counsel are entitled to know that as part of the discovery process.
Well, okay, you know, we run into a lot of situations where there are several different carriers for the same defendant, and based upon time on the risk and other factors, they will develop an agreement as to percentages of defense costs, but that doesn't apply across the board to what the indemnity money would be, because if their coverages are all triggered, the potential would be for all of the limits to be exposed, regardless of whatever side agreement there might be on defense costs. And I agree that that would be discoverable because we have to provide, in New York, we have to provide what the available coverage is and the limits.
All right, so we are going to take our lunch break. We have a great panels in the afternoon. We have the judges panel, a couple of judges panel. We have an appellate panel, and we have starting off the Roberts case, which is a hotbed of concern among those of us who litigate these cases. That's starting right after lunch. I hope you all come back because we got good stuff for you this afternoon.